it can, or by the action of the ODPP exercising their power under Article 157, can actually amount to a limitation of a right, and that is what you want to go and argue in the High Court. And we are not offended by your findings. We are offended by the legislation. That the legislation is purportedly limiting you to protect a right. 14 days, Your Honor, is not so much to ask. Honorable Jayne Kihara will still be within the jurisdiction of this court. She will be available and she will be subject to you. So we can have a mention in 14 days to confirm the outcome of our proposed petition. If this, Your Honor, is not going to be done, you'll see a litany of members of parliament appearing before you. Even myself, I may appear before you, especially when I say one term. I'll be next. Especially when I propose a doctrine of one term, which you propose out there. So, you know, or the member of parliament for Katanga. So, you know, we urge you to grant us this stay, subject our arguments to those three tests: who suffers prejudice, whether the proceedings will be rendered nugatory, whether they will amount to academic exercise, and whether it is justicious for us to move to the High Court and check the possibility of Article 10 giving and Section 8 of the Rights Court taking. Thank you.
You know, you might be saying all that and the state is considering.
We will come to the concession.
I have a few comments. You know, as you have rightly stated in your ruling, the only issue for consideration here would be whether the charge sheet that we presented before you was proper under Section 134 of the CPC, whether it discloses a known or existing offense, and whether the suspect hearing will be able to defend herself or rather understand the charge well enough to put in a defense. And those questions have been answered in the affirmative by your ruling. Yona has also distinguished what pertains to freedom of expression under Article 33 and whether this court can deal with issues pertaining to limitation of some rights under the Bill of Rights, and as rightly stated by the court and the authority that the court alluded to, the only violations that this court can entertain in line with Section 8 of the Magistrates Court Act are the ones under Article 25A and B. At this point in time, plea taking may not bar the defense from moving to the High Court for a constitutional interpretation. Decisions of any court higher than this one are binding on this court. I have not heard them indicating to us the prejudice that the suspect will suffer once she takes plea. The office of the DPP will also be bound, is also an office that is bound by decisions of the higher courts. When we were here last before you, the argument by the defense was that the charge sheet presented offended sections of the law. That the court has dealt with. So, Your Honor, it is our submission that nothing bars the suspect from taking plea at this point. They can move to the High Court for interpretation of the section of the articles that they indicate. Once the High Court pronounces itself, then this court will comply with those orders. So at this point in time, the suspect is before court. The court has indicated that the charge sheet is proper. So we oppose the application for deferment of plea. That is all.
I'll ask the regulator report on the issue that she has raised of countries.
You know, I take it that the prosecution has not controverted our arguments. Other than subjecting a question to us that we have not indicated the prejudice she suffers, that is on record. She has not urged you to find that you suffer any prejudice whatsoever. And to the best of my knowledge, is that the office of the ODPP is an independent office. They are bound by the decision of the Supreme Court or Superior Court. Yes, but not their decision to charge, because that is independent under Act 157. What we are asking, Your Honor, is within the provision of the Constitution at 165 clause 3D, that the High Court may have the opportunity of determining whether anything said to be done has been done in accordance with the Constitution. And therefore that's how we shall be invoking the jurisdiction of the High Court. And the same can even be exercised if we were to invoke the supervisory jurisdiction. But we are not asking the High Court to supervise you because you have not made any error. We're not asking the High Court to supervise you. We're asking the opportunity to test whether anything said to be done by the ODPP has been done constitutionally. That's why we're not invoking the supervisory jurisdiction. And as such, our argument, Your Honor, remains uncontroverted. We are most obliged.
So, if I can get you well, you say this, if I allow this, it will be a threat to MPs.
I think I'll invite my learned friend who is a political animal to answer that.
Honorable members, yeah?
Yeah, this is very serious, and because this is what you call guarding. Because, as I said in my submission, the role of Parliament is to represent an oversight. You don't represent an oversight in silence. You expound the wishes and aspirations of the people who have voted for you. In fact, it goes to the good norm of the fact that why did you even vote me in the first place if you got me? And that's why we are saying, Your Honor, it is very important that we be allowed to go and make that interpretation. Because what will happen eventually is that if me as a member of Parliament for Gachagua'S constituency, I'm gagged, you as a magistrate, you're also going to be gagged because of making certain decisions. And therefore, this freedom is not for members of Parliament. This freedom is not for the members of the press. This freedom is not for, is for every citizen as guaranteed by Article 3. And therefore, it's very fundamental that we get that opportunity for the good of this country. Thank you.
So I've heard your arguments and submissions. So first of all, I'll share with you the ruling on question of controversy and the other issues that you were shared. And then I'll request you to come on Tuesday next week. So in the meantime, I'll extend the bond terms. Because I got their bond terms. But one thing I want to request, as a court, is a hallowed temple of justice.
Yes, sir.
And we would want it to be, we are political as a court.
That's correct. That's why you never said one time.
Yes, so you just said that. So some statements, and I was told, and I take judicial notice, I was told that there were chance of that what you just said there. So I'll just respectfully,
You're most obliged.
with all humility, I think, so that we can maintain the dignity
That's correct.
of this hallowed temple of justice.
That's correct.
Let's not utter such words.
We'll advise my
Once you're out there at the gate, you can shout the top of your voice. But once we're within here, let's just, you can sing the national anthem.
We are
told last time you guys, which is quite patriotic. But some of those utterances or chants, let's just keep it off.
We are grateful and
Yeah,
apologies.
because we want to maintain the dignity of the court.
We are most obliged.
Because we're purely a political, yeah?
We are most obliged.
Because we have to speak for each and everyone.
Absolutely.
Whether you're a member of parliament, whether you're a normal citizen. Yeah. We're all people before the law. So let's just respect that. Let's not, once I leave, I'm sure that, like last time. So
No, you know,
so I've extended a bond terms to Tuesday, the 5th of August.
if kindly allow us to convey our apology, that will not happen again. We shall allow them to sing the national anthem, but that will not happen again.
Yes, we are trying to, we appreciate and the extension. Can we request you to give us Wednesday instead of Tuesday? There are a number of related cases. And another.
So can we agree also on the sign?
Okay?
Sorry, I am corrected by my own friend, while I think supposed to be the member of parliament. Like it's 7. Yes, we are requesting for 7.
At 11, Your Honor.
7 at 11. So you'll be exactly at 11.
We are most obliged.
So I thank you. Also for you understanding it, I was a bit late. My sincere apologies.
It's okay.
But in the evening you'll get the ruling.
We'll get the ruling by today.
Yes.
By today, so that we can also get back on the other exercise.
Indeed.
Most obliged.
So I still have the matter, so I'll excuse you so that you don't understand.
Much obliged.
Much obliged.
The main party has seen another comment to say about the excuse of politicians.
I wish you all a good afternoon.
Please maintain silence, the court is still on.